All right, good morning. And all right, good morning. We will go ahead and just get started. My name is Amelia Green, and I am the marketing coordinator here at Smith Freed Everhard. Thank you very much for joining us on today's presentation, An Introduction to Traumatic Brain Injury Claims in Washington. I'm going to go through just a quick few household items before we get started here today. So, as we go through today's webinar, please do feel free to ask as many questions as you like. You have a little question box, which is in your GoToWebinar control panel, that you'll be able to anonymously ask questions there. We will try to address your questions as we go, but we will also have a 15-minute Q&A period at the end of the webinar for any further questions. If for any reason we do not get to your questions during the webinar, we will follow up with you personally, or you will also have our presenters' contact information, and feel free to reach out to them as well. Later today, I will email everyone a short survey on the webinar. We really do appreciate anyone who takes the time to fill that out. We really do listen to your feedback and really appreciate it, and we try to offer as many valuable resources as possible to the insurance community. So we really do appreciate anybody who takes the time to fill that out. With the webinar follow-up email, it will also include a spot for you to submit your name and license for CE credit. Today's webinar is approved for 1 hour of general CE credit in Oregon, so if you're interested in that, please keep an eye out for that follow-up email so you can submit your name and license number there. In addition to today's webinar, we also do have several other legal resources covering both Oregon and Washington law, so please visit our website anytime for access to all of that information. We do have webinars available on demand as well. I will go ahead and introduce today's presenter today. Today's presenter is Gordon Klug. Gordon Klug is a partner up in the Seattle office, and he is licensed in Washington State. His practice areas mainly include commercial liability defense, personal lines, premises liability, job site injury, negligence, construction defect, and products liability. Gordon also has a significant amount of experience in handling TBI claims and has taken over 50 cases to jury trial. So I am sure many of you are already familiar with SFE as a firm as well, but our firm has over 35 years of experience in litigating cases and is recognized practice experts in commercial general liability, premises liability, bodily injury, product liability, employer liability, construction defect, and personal line claims. Well, I hope you enjoy the webinar, and I'll go ahead and turn it over to our presenter, Gordon.
Thank you. Thank you all for showing up today. I really do appreciate it. Traumatic brain injuries is kind of my specialty in terms of trying cases, and it's something that kind of piques my interest. It's a complex type area of the law, but it's not overly challenging if you know how to navigate the various challenges that you'll encounter while handling a TBI case. I want to give general ideas to the course outline. We're going to be talking about, well, what is a TBI? I'll give you a little bit of a historical perspective on traumatic brain injuries and how they arose, as well as dive into what doctors look at when diagnosing a patient to see if indeed they do have a traumatic brain injury. If the patient has a TBI, we will also look at how doctors go about assessing the severity of the traumatic brain injury and providing recommendations for future treatment. We'll also be looking at various studies about what the prognosis is for people who sustain traumatic brain injuries. And then finally, I'll move into what I look at when handling TBI claims that are being litigated and we end up taking it to trial. We have a significant amount of information we're going to be covering today, so there's going to be a lot packed in here. I'll take questions at the end, but I just want to apologize up front about having to move relatively fast. So when you're thinking about traumatic brain injuries, there's one question I want to kind of put in your mind is TBI the modern day Trojan horse? When you think about somebody who says, I sustained a traumatic brain injury, oftentimes people think in terms of, oh my God, this is absolutely horrible. You were probably put into a coma, hospitalized for months, and you can no longer carry on with your life, and you may end up having to be bedridden for a significant period of time. But when you actually look into TBI cases, studies suggest that, well, it's not necessarily the end of the road for people. The vast majority of people do recover from traumatic brain injury claims. When we're looking at traumatic brain injury claims in litigation, there is a battle line that's set between plaintiffs and defendants. Plaintiffs like to use what's called subjective information. They will present complaints of pain if the photos show a graphic car accident or a significant accident of some sort, or if there are photos of the injury itself. They will put that information front and center. So the plaintiffs kind of come at TBI claims from a fear perspective. They want to generate fear within the jury and use sympathy as a basis to trigger what we call a premium jury verdict. A good defense for TBI claims is objectivity, presenting evidence as to what is objective about the plaintiff's condition and whether there's anything objective with respect to the traumatic brain injury, if there is any sort of evidence of it, as well as if there's a life care plan or a request for future treatment, what is objective in terms of concluding that such life care plan is actually necessary in the case. So I think it's always a good idea when we're thinking about traumatic brain injuries to kind of get a general idea as to, well, where did they come from and what exactly are they? As the 5th century military strategist Sun Tzu once said, know thy enemy. So if you know about where TBIs came from and you know what it is that doctors look at and what the literature and the studies show regarding TBIs, you'll be much more successful in terms of not only properly evaluating a TBI claim, but also defending them at trial. So the first question really is, well, what is a traumatic brain injury? And it really depends on who you talk to. Various people, and these could include doctors, they will have different definitions of a TBI, and oftentimes they will mix up TBI with head injury, with closed head injury, with concussion. And so when we're talking about, well, what is a traumatic brain injury, some people will say that it's as little as a bump on the head and there's absolutely no bruising. That was something that was traumatic that led to what they allege was a brain injury, but it was really just a bump on the head. Some people will say that it's a scrape on the head with some sort of laceration or bleeding. Others will say it's a bruised brain caused by whiplash. But your standard definition of a traumatic brain injury is that it's some sort of a trauma to the head that results in neurological deficits. Some of the neurological deficits that people who experience TBIs may see is memory loss, dizziness, confusion, personality changes, anger issues, depression, tinnitus, and speech deficits. So I want to show you a video here. This video is a little bit graphic. It shows a professional skier who sustained a traumatic brain injury, and it does show that him at the end convulsing on the ground. So if you're a little squeamish, you might want to look away. We tried to edit out the convulsing part, but it really kind of ruined the overall video for us, so we kind of kept it in. So here you see Scott McCartney. He was in a downhill ski event. It was the first run of the day. He missed his jump and he ended up hitting the ground fairly hard. and knocked himself out cold, and he ended up having a very significant injury. At the end of the at the scene, he ended up being helivaced out of the ski slopes and taken to the hospital. And so when people think of traumatic brain injuries, some sort of a image such as this is what comes to mind quite often. So the good news about this case is that he did end up recovering. Scott McCartney was a downhill skier, professional skier. That accident occurred in 2008. He suffered a significant traumatic brain injury that resulted in severe bruising to his brain. His doctors actually put him into a medically induced coma. He did regain consciousness the next day, but he made a remarkable recovery. Here on the right, you see a photo of him and his family with his children, and he did go on with life. Today, he still skis with his children, and he heads up a nonprofit organization for underfunded winter sports athletes. So even though you can sustain a significant injury, some people do go on with life. Now, traumatic brain injuries haven't necessarily been around since the dawn of time. I mean, they've been there, but people haven't really necessarily recognized them as such. I want to give you a little bit of an idea as to kind of how they came onto the forefront with medicine. In the military, through advances in treatment of soldiers who were wounded on the battlefronts, the military started putting their surgeons within about a mile of the front lines, and then they would helivac the injured soldiers directly to the mobile hospital and provide them with treatment on the spot. And so what the military found was that there was this golden hour where they could actually save soldiers' lives by being closer to the battlefield and also providing them with the treatment that they needed. But what ended up happening was that these soldiers started to be left with some sort of residual symptoms, such as ongoing headaches, visual changes, emotional changes, photophobia, or things like that. And so the military, even though they were able to improve the survivability for the soldiers started experiencing symptoms which we now recognize as traumatic brain injuries. And that started back in as early as World War II, but more so with the Korean War and then into the Vietnam War as well. Now, the 2001 military operation in the Middle East, Operation Enduring Freedom, there were approximately 1.6 million soldiers, U.S. soldiers, who went into that theater of battle. And the military found that there was a relatively high rate of people who sustained mild traumatic brain injuries. That was around 19.5%. Another 15.2% sustained concussions. Now, you don't need to be a soldier to sustain a traumatic brain injury. Here's an example of Bob Woodruff. In 2006, he was working as a correspondent for ABC News. He went to the Middle East to cover the war there, and one of those IEDs, implemented explosive devices, detonated near him, sending shrapnel to his head, and he sustained a very extensive brain injury, and he did have some permanent impairments. During his convalescence, his brain started to swell, and one of the common treatments that doctors perform for triage purposes is to either put the patient into a medically induced coma or remove a portion of their skull so as to allow the brain to continue to expand. If you didn't do that, the brain would expand up to the inside of the skull and then end up the patient would end up having more serious injuries or long-term disabilities. So you see on the left, Mr. Woodward in the hospital, and he did recover from his brain injury. He did not return to work as an anchor for ABC News, but he did return to work as a correspondent, a field correspondent. So he continued on with his career. This aspect of people sustaining traumatic brain injuries and continuing on their lives does happen with a fair degree of regularity. And that's more of the norm than the exception. Now, over 100 years ago, in 1905, President Roosevelt's son was playing football on his school's team, and they had 19 players that year who died due to game-related injuries. Significant of those injuries were head injuries. At that time, they didn't quite recognize what was causing these neurological deficits. So President Roosevelt called coaches and experts to the White House to figure out, well, what should they do? And at that time, the best that they could do was modify some of the rules of football. They introduced the forward pass. They abolished what they used to call mass formations. They also doubled the first down distance to 10 yards. So over 100 years ago, yes, people were still experiencing traumatic brain injuries. They didn't know how to treat it from a medical standpoint, but they did recognize that it was a serious problem that they needed to address. And the way they had tried to address it was to make the game of football a little less injurious to their players. And that actually has continued on to the current date. In the past 10, 15 years, there's been the rise of what's called chronic post-traumatic encephalopathy. That is a condition that develops as a result of a number of micro hits or micro traumas to the brain. And football players were experiencing this. Now, there is no way when the player is alive to diagnose them with chronic CTE. You only can find out if a person has CTE after they've passed on. You end up taking a slice of their brain, imaging it, and then you will see with CTE is that the patient actually, their brain starts to resemble more like Parkinson's or old age. Their brain starts to desiccate. And that the NFL found was kind of prevalent with football players. There were actually a number of notable players who ended up suffering from this condition. Andre Waters with the NFL, he was a safety. In 1984, after he passed on, they examined his brain, did find evidence of CTE. On the college level, a player named Owen Thomas, he had no prior concussions or any significant head blows to the head while playing college and high school football, but in 2010, he ended up committing suicide. They conducted an autopsy on his brain. They found that he had CTE. So the football has shown that you don't have to be in a traumatic event, such as a car accident or a single episode of trauma, in order to develop a brain injury. You can actually, it can occur from these micro traumas where the player may not even know that they sustained any sort of a trauma or injury to the head. Dave Duertson, he was a safety with the Chicago Bears. He was also a player's rep for the NFL. Towards the latter part of his life, he suspected that he was having problems with CTE. He was experiencing anger bouts, personality changes, depression. His view on the world turned very dim and dark, and he ended up committing suicide. But he wanted his brain to be preserved so that they could determine whether he did have CTE. So after his death, they did find that, yes, indeed, Mr. Duertson did sustain and develop CTE. So what we see with these prior studies in the military and in the football was that advances in medicine have given rise to people surviving initial trauma, but oftentimes, they would start to develop neurological deficits. So they survive death, but they end up having serious neurological deficits. And what we see with the football examples is that you don't have to have a traumatic event or a traumatic accident to the head in order to develop a head injury. It can happen from a number of repeated exposures over time. And so in terms of litigation, if you have a plaintiff who had no prior trauma to the head, didn't play football, or there was no reason you would think they had experienced micro traumas over a prolonged period of time, those people, we found that they tend to recover a lot better and a lot sooner than if the patient has had repeated exposures or repeated traumatic brain injuries in the past. And it's kind of contrary to your standard insurance claim, where if you have, for instance, a plaintiff who's complaining of neck pain, and you know pre-accident the plaintiff had a number of other collisions all injuring the neck. And so there, what you're trying to do is you're trying to apportion, well, what part of the plaintiff's damages is related to the accident versus something that's pre-existing and unrelated. But within the CTE or in the traumatic brain injury context, it's not that straightforward. If you have a plaintiff who did sustain a prior traumatic injury to the brain, the natural tendency is to argue that, well, the post-accident treatment is designed to address that pre-existing condition. But the evidence has actually showed that once you have one traumatic brain injury event, that makes you more susceptible to future TBI claims later on down the line. And those subsequent claims of TBI they do not have to necessarily arise out of a significant motor vehicle accident. They can arise out of something as small as possibly a low-speed type collision. So let's shift gears here and look at, well, what do doctors look at? What are the facts regarding TBI? Doctors typically state that a traumatic brain injury is defined as an alteration in brain function or other evidence of brain pathology caused by an external force. So the things to keep in mind here is that you have an alteration in brain function that's proximately caused by an event. So in a traumatic brain injury claim, you have to have what's called a concussive event, some sort of trauma that ends up trauma to the head. If you have a plaintiff who didn't hit their head on anything, that suggests that there may have been no trauma on the head, but you can still have kind of one of these called coup contre coup type injuries to the brain if the plaintiff sustains whiplash. So if they're just sitting in their seat and they're rear-ended from behind, their head might move back, slam against the back headrest, and then if there's another forward movement, the plaintiff may actually experience two traumas. So you end up moving forward and possibly sustaining some sort of a trauma to the front of the head. Now, when you think about the brain, it is a soft tissue organ that's contained within spinal fluid. It's just floating in your skull, and it's surrounded by a very hard casing. And so the process of having your head snap back and snap forward could also, shift that brain so that it ends up making contact with the rear of the skull and the front part of the skull. So you can still have an injury to the brain caused by an external force without the plaintiff actually hitting the windshield or hitting the side of the side window. The key here is whether there is any evidence of brain alteration that's caused by some sort of an external force. And a lot of people argue or claim that, well, hey, I had a concussion, so I have a traumatic brain injury. Well, a concussion is more like a bruise, whereas a traumatic brain injury is a complex physiological event that leads to an alteration of brain functioning. So what is alteration of brain? What are some of the symptoms of altered brain function? You can have, and you don't necessarily have to have all of these in order to be considered to have sustained a traumatic brain injury. You can have a period of loss of consciousness or a diminished level of consciousness. You can also experience confusion, disorientation, slow thinking, or have memory loss if you lose memory of events before the accident. That's called retrograde amnesia. Or you could also experience memory loss for events after the accident for a certain period of time. That's called post-traumatic amnesia. Some of the other symptoms of an altered brain function would be neurological deficits such as weakness, loss of balance, change in the vision, paralysis, sensory loss, things like that. And again, when you're talking about a TBI, you don't have to have all of these symptoms. What doctors look at is just, well, what symptoms do they have? And depending on the doctor, they may make a diagnosis of TBI at that point, or they can move on to doing some additional testing that we'll talk a little bit more about here later on. So the vast majority of the claims in the U.S. And then also the claims that we're seeing in litigation are what are called mild traumatic brain injury. So the mild traumatic brain injury typically is a condition where the imaging of the brain is negative. There may not be any neurological deficits, and if there's any sort of alteration of consciousness, it's typically for a very brief period of time, lasting minutes to hours. That is the signs and symptoms of a mild traumatic brain injury, and that's the condition that we're going to focus more on with this presentation going forward. Mild traumatic brain injury prognosis. Key thing is, and as we saw, even with more severe TBI claims with the skier and such, the majority of patients make a full recovery, especially from mild traumatic brain injury cases. Now, the recovery can take up from a week to sometimes up to 3 months, but most patients do have a favorable functional recovery. They resume normal social and occupational activities within days to weeks. Up to 25% of patients, though, might have persistent symptoms that might last for several months or possibly years if they sustain a mild traumatic brain injury. So what do doctors look at in terms of trying to evaluate how severe the brain injury is? And not only that, but what type of treatment do they normally provide? There's two different types of, I guess you can say, ways that doctors will look at evaluating a patient for a traumatic brain injury. One, you might have a doctor who focuses more on the complaints by the patient. That is arguably a little more subjective than if you didn't rely just on complaints. Take, for instance, complaints of pain. There is no apparatus in science that can actually measure whether somebody's experiencing pain, let alone how severe that pain is. Pain is just purely subjective evidence. The patient could be saying they're in a lot of pain, but there's no way that you can verify that directly outside of the plaintiff's own words. Other ways that healthcare practitioners have used to evaluate the severity of a head injury is to use testing of various sorts. There's the Glasgow Coma Scale. There's also neuropsychological testing. Neuropsychological testing typically is 2 to 3 days of testing. They look at personality issues, brain functioning, memory, processing information, attention span, things like that. But the big, I guess if you can call it an objective measure, or the way healthcare practitioners have used to try to determine if somebody sustained a TBI, is what's called the Glasgow Coma Scale. It was developed in 1974 by Drs. Teasdale and Jennett. And the doctors look at 3 different axes and then rate the patient on a scale of 1 to 15. If the patient has a Glasgow Coma Scale of 13 to 15, that's considered mild. If it's considered, if their score is 9 to 12, that's moderate, and then if it's 8 or less, it's characterized as a severe traumatic brain injury. Here is the Glasgow Coma. I don't know if you want to call it a score sheet, but it's what the emergency room physicians and also paramedics will look at when determining how to scale somebody using the Glasgow Coma scale. They will look at eye and verbal responses as well as motor responses. And for instance, and the big thing here is if you look at the testing itself, there's a certain amount of subjectivity in there. For instance, if on motor skills, if flexion is normal, they're given a 3. But if the motor skills, the patient withdraws to touch or to pain, they're given a higher scale. So, and this is kind of the best response that the paramedic or the healthcare practitioner sees when examining a patient. So, to a very large extent, whether something flexion is abnormal or normal or below normal, that is to a certain extent, a subjective interpretation by the tester. So what one person may think is abnormal, another doctor might actually say it's normal. And so you end up having possibly different Glasgow Coma scale findings depending on who provided the exam. So when I first started this presentation, I talked about how the battle lines are between subjective and objective. Defense, we're always looking for what's objective. Now, the Glasgow Coma scale, as well as the neuropsychological testing, so much of that is quasi-subjective. It depends on the interpretation by the tester. So, there's a certain limit as to how objective you can get in evaluating just whether somebody does sustain a traumatic brain injury. So if we're looking at mild traumatic brain injuries, typically what healthcare practitioners look for is a Glasgow Coma scale of over 13 for less than 24 hours. Patient may experience headache, dizziness, or nausea, and they may also experience an unsteady gait, slurred speech, or poor concentration for a relatively brief period of time. So what about if you have a patient who does have a traumatic brain injury? Well, what's the prognosis? What's the normal expected outcome from that condition? What the healthcare community has kind of classified long-term sequela for TBI claims is 3 different types of potential long-term problems: post-concussive syndrome, post-traumatic headaches, and then also epilepsy. But if you look at the treatment that the doctors provide for TBI, so often the treatment is just designed to address symptoms as opposed to curing the underlying condition. So post-concussive syndrome, what is that? Well, it's persistent symptoms, neurological symptoms that's lasting beyond the acute concussion recovery. Now, acute typically means 6 months or more. So if the patient has ongoing problems such as fatigue, headaches, difficulty concentrating, irritability for more than 6 months, then doctors will say that they have post-concussive syndromes. Now, post-concussive syndromes can typically last for weeks, months, or even years after the development of a mild traumatic brain injury. Let's look at post-traumatic headaches. Post-traumatic headaches are headaches that have an onset within 7 days of a neck or head trauma. Now, the rates of post-traumatic headaches in patients who sustain mild traumatic brain injuries is between 30 to 90%. That is based upon the reason for the variability is because people who are younger usually tend to resolve relatively fast, sooner than people who are older. People who have comorbidities tend to have a more difficult time recovering from trauma than people who are otherwise healthy. But what we've seen here is that post-traumatic headaches, even after a mild traumatic brain injury, do resolve at a certain point in time. And you can't necessarily diagnose or confirm if somebody has post-traumatic headaches based on CT scans. But the big key here is that most people do resolve, even if they sustain post-traumatic headaches. Some patients might actually experience epilepsy. Now, epilepsy usually happens when there's a fracture of the skull or an intracranial hematoma, and there's depressed levels of consciousness at the time of admission to the emergency department. Also, if a patient starts to experience seizures within about a week after the brain injury, what they call early seizures, that appears to be a risk factor for patients to develop later long-term recurrent epileptic events. Now, when we're talking about epilepsy, the big thing that people look at are the types of seizures. You have the grand mal seizure, which the patient, their eyes end up rolling in the back of their head. They start possibly drooling and shaking, depending on the severity of the grand mal seizures. But you can also have patients who they just zone out or they space out for 15 seconds at a time, or they might have some attention issues for a brief period of time. Those are called petit seizures, but that also could be a condition that people experience if they sustained a traumatic brain injury of some sort. The early onset of epileptic seizures doesn't necessarily mean that they're going to have a problem post-traumatic, an ongoing problem as well. I mean, it kind of more or less depends. But the interesting thing about the seizures is that people who have seizures 5 years after a traumatic brain injury was about 0.7 for people who had mild traumatic brain injuries, 1.2 for moderate, and 10% with severe TBI. Now, the risk of seizures in the general population who have never sustained traumatic brain injuries at all is around 0.5 to 1%. So people who sustained mild traumatic brain injuries and claim that they're experiencing seizures, well, the rate of those seizures is not that different than what you would see in the general population had the patient never had an injury to the head. So I want to move on to another video here. This one's not as graphic as the last one, but it kind of illustrates another example of, I guess, a post-accident success story. So here we have a professional skier, Lindsey Vonn. She is competing in a skiing event. She has a fall, ends up hitting her head on a ski gate. She's knocked out cold. And it looks like a pretty significant injury, obviously enough to cause your average person to be concerned about their welfare. But what we've seen is that she made a full recovery. The accident we just saw on the video is in 2011. She was participating in a downhill skiing event. She made a full recovery, and she went on to compete in the 2018 Winter Olympics. Today, she's retired from professional skiing, and she focuses on other activities such as launching a line of her own skiing clothing. So here's another example of somebody who sustained a serious injury to the head, and they recovered. Similar to the news broadcaster that had a very serious brain injury, and he went on with life. He recovered, as well as the earlier skier that we saw. He also recovered. One of the things that doctors who handle head injury claims have seen was that if you have a patient who's motivated, and also does not have a lot of comorbidities, they tend to recover sooner and without prolonged complications than people who are not motivated or do not have comorbidities. So you look at the patients who have in a sports event. I mean, usually after they recover, they try to get back on the horse, as it were, or on the ski slopes, get back to doing things they enjoy in life, and then they put the brain injury behind them. They move on. But you also have another subset of people, and you'll see them a lot in the litigated setting, where they're not motivated to go to move on. They focus on their head injuries, and they may have comorbidities which hamper their ability to resolve, but there's the issue of motivation, in terms of their recovery. So again, when we're talking about defending against a brain injury claim from the defense standpoint, we look at what is objective. What is it that's objectively keeping somebody from moving on versus something that's subjective, moving on. So I wanted to also show you what I do when I have a TBI claim that's referred to me. Well, first thing I do is I obtain everything that I can that shows me objectively what the plaintiff's pre-accident condition was. So that'll be found in their medical records, as well as any sort of standardized testing, school transcripts. I will do a social media search so that I can see what their posts were like pre-accident, compare them to post-accident. If a lawsuit's been filed, I will also depose the plaintiff and do a video deposition. The significance of that is that I want to show that video deposition to an expert if this is a case that we're looking at hiring one, and that neuropsychologist pays particular attention to not only body language, but how the plaintiff is able to express themselves, and whether there's any sort of neurological deficit. So if you have a video deposition where you have a plaintiff acting in one manner in the deposition, then the healthcare practitioner will also observe the patient during their own testing, and they can compare, are the two periods of interacting with the plaintiff consistent with each other, or are there some differences? Depending on the extent of the TBI claim, you would probably want to also consider hiring a neuropsychologist, possibly to do cognitive testing. This all, again, depends on the nature and extent of the claim. But one of the things that we found in my jury verdict searches is that for those cases that a jury awards a premium on traumatic brain injury claims, though a defense isn't really prepared to handle the case. They haven't hired, for whatever reason, haven't hired experts. I've seen some verdicts where the plaintiff had a neuropsychologist and a psychiatrist. They really, focused on the head injury aspect, and then the defense hires a orthopedist to address just the physical issues. They ignore the TBI claims, and then once all is said and done, they get hammered by the jury. So when we're looking at what is the threat on TBI claims, yes, the vast majority of patients do recover, and actually in my jury verdict searches, specifically in Washington, most juries do not assign a premium to TBI claims, but it's like lightning. It rarely happens, but when it does strike, it can be devastating, and oftentimes it strikes when the defense isn't designed to address the head injury claims head on. They more or less are trying to ignore it or minimize it. So in a TBI claim, it's not unusual if the plaintiff's attorney hires an expert to create a life care plan. So what I typically do with that is I meet with my own expert, neuropsychologist or psychiatrist, and I look at, I discuss with them, well, are there any treatment needs? Do you think this plaintiff needs any future treatment as a result of the injuries sustained in this accident? More often than not, they say no, they've received enough treatment, or, they've resolved. I also evaluate whether to hire a vocational expert, and I know some carriers are a little shy in terms of hiring folks. They think, well, they don't really add a lot of value to a head injury case. Again, the problem is when you go in front of a jury and you end up having a plaintiff who hires a vocational expert who presents this multi-million-dollar life care plan, and the defense doesn't have anything to say, no, that life care plan, isn't needed. You don't have a similar voc saying the same thing. Oftentimes, jurors will just make a very simplistic conclusion and say, well, they've got a voc, defense doesn't have a voc, so I think the life care plan is in. When I'm looking at a life care plan, some of the experts that I look at are possibly hiring a billing expert and an economist. So when you look at, well, and we're just talking about damages here with a jury, when you look at what it is that a jury can award for damages, they award special damages and general damages. Special damages are damages you can measure, such as a medical bill, lost wages, things like that. General damages are for pain and suffering, loss of opportunity, loss of chance. They're things you cannot directly measure, but the jury is still going to put a value to that. So more often than not, juries look at the value of special damages when concluding how much to award for pain and suffering. So one of the big things that I highly recommend doing with TBI claims that are going to be in front of a jury is shrink the value of special damages. And the way you do that is you not only hire a neuropsychologist who, says, yes, they do have a head injury, but treatment shouldn't last as long, or no, they have no head injury, but if you hire a billing expert, that billing expert is able to look at the value of the bills, and then more often than not, that billing expert is going to say, well, that's not the usual and customary charges for these different, this different type of treatment that was offered to the plaintiff in the past. Same thing if there's future treatment, they will look at the values of future treatment and offer more often than not they'll say, well, no, that's inflated. That's not the usual and customary charges for future treatment as well. So the billing expert, in my experience, when I hire them, they're able to shrink medical bills down by a third or so. So if you have $100,000 in medical bills, if you hire a billing expert, they will compare the CPT codes to the actual chart notes and then say, well, the usual and customary charge for that emergency room visit is $500, not $1,500, and they'll, do that throughout all the treatment and overall shrink the value of past and future special damages. And then if you hire an economist, the economist can do two things. One is not only tell you the value of any past treatment. That's just math. You don't need an economist to do that. But the value with the economist is to discount future wage loss and also future treatment to present value. And I'll talk a little bit more about that here coming later on. The other thing that I look at in handling TBI claims is evaluating risk transfer opportunities. And what do I mean by risk transfer? Well, if we have a situation where maybe the insurance policy is not going to cover the accident for whatever reason, or if there's not enough coverage, what I aggressively do is I look for other avenues of insurance. So I will ask my client if you have any other policies. If it's a commercial claim, I'll ask if there are any other umbrella policies or auto policies that might be relevant. If it's a case where the insured is a company and they hired a subcontractor, well, I'll look at the contracts between the client and the subcontractors to determine if there was any sort of risk transfer opportunities in terms of indemnity or duty to defend clauses, or to procure insurance for us, and I will tender to those carriers. So I want to spread the risk as much as possible. Now, during negotiations, plaintiff's counsel, and this happens a lot in TBI claims, they will use policy limits as leverage against carriers, and many of you have more likely than not seen this several times in your own experience. If there's no coverage or if there's insufficient coverage, the plaintiff's attorney will leverage that, asking for the policy limit. And they realize that the carrier has possibly two duties to their insured: duty to defend and duty to indemnify. And they're two different separate types of duties. A duty to defend is determined based upon the four corners of the complaint, and if there's arguable coverage, then the carrier has a duty to defend. And the duty to indemnify is just triggered based on the language of the policy. So if the policy says we don't cover motor vehicle accidents and the accident was a motor vehicle collision, the carrier may not have a duty to indemnify. But there's two very distinct possible duties that carriers may have, and plaintiff's counsel will exploit both of those duties. They will either do so indirectly or directly. They oftentimes do that through asking for settling for the policy limit. They will say that, okay, you're insured as $1 million policy. I've got a $5 million life care plan. You better give me this $1 million by next Tuesday. If not, it's forever withdrawn. We're going to go to trial. And you as the carrier are treating your insured in bad faith. There's case law that does state that if a carrier has an opportunity to settle for policy limits but does not do so, and then there's an excess verdict, that could be a claim of bad faith. Or the other ways that plaintiff's counsel will ask for or exploit the policy limits or no coverage issues is by asking the insured directly for an assignment. I don't see that as much now. I saw that more so back in the late 90s and early 2000s. But post-trial, if the case does go to trial and it results in an excess verdict, plaintiff's counsel will oftentimes approach the defense and tell them, hey, we don't want to take your house. We'll agree not to execute against your personal assets, but we want you to assign your claim of bad faith to the carrier over to the plaintiff. And then they go back, once that's done, they go back to the pre-suit policy and limit demand and then file suit against the carrier saying, look, I told you I wanted your policy limit, and now I've got, you didn't pay that $1 million back then, and now we've got a $10 million policy, so now you have to pay not only the total amount of the verdict, but treble damages and attorney fees. And so that's another way that plaintiff's counsel can exploit a situation where the carrier may not have coverage for that particular loss, or there might not be enough in terms of the policy limits. So aside from the issue of risk transfer, what are some of the, when I'm evaluating a TBI claim, what is it that I look for? Now, since I'm a lawyer, I look at, well, what is the law regarding damages, and what is it specifically that the court is going to instruct the jury about the use of experts, proximate cause, and discounting to present value. These are the three jury instructions that I look at when evaluating, well, what's a jury going to do? So let's talk about these three jury instructions. And depending on your state, most states have either this, these similar instructions to Washington, or something substantially similar to it in their own state. So these jury instructions are not necessarily unique to Washington, but you may have something similar in your own state. But you want to check to see what are the jury instructions for the use of expert testimony, as well as proximate cause. What does the court use in terms of explaining to the jury the meaning of proximate cause, and then that discounting to present value. So the use of expert testimony, the experts can use information that's given to them. It's called hearsay when arriving at their own opinions. And so one of the things that the courts tell the jury is that, well, you can, a certain expert or person who has special training, education, or experience may be allowed to express an opinion, but you're not required to accept his or her opinion. So you will have plaintiff's experts who will say one thing, defense saying another, and the court is saying, well, you don't have to, believe one expert over the other. In order to determine which one to believe, you look at other things, such as their education, training, experience, knowledge, and ability of the witness, as well as other factors and basis for their opinions. And so often plaintiffs experts will offer an opinion about a condition based on just what the plaintiff is telling them. I've seen cases where doctors have said, yeah, I think I have a head injury. Why? Because my patient says they have a head injury. It's as simple as that. Or they base it upon, well, they have a head injury because they said they hit their head and then they started complaining of pain. So, it's a little bit different than saying my patient told me so, but it's not much different. But if you have an expert who actually goes, and bases an opinion upon psychological testing, that's a different type of an animal. So when looking at expert testimony, I evaluate, well, what's the basis for the expert's opinions? A lot of times, plaintiff's experts will also couch their opinions on things that are very subjective. Like I mentioned, complaints of pain, photos of the accident, complaints of headaches, dizziness, whereas defendants, we base our expert opinions on things that are as objective as we can, such as neurocognitive testing, MMPI, and depression inventory tests. So often at trial, you will also have experts that will say, well, it's possible. It's possible that the plaintiff has a head injury, or it's possible they're going to need 25 years of future treatment. And the defense doctors, typically, they couch their opinions on a more probable than not. So on a more probable than not, they do not have a head injury, or on a more probable than not basis, they don't need any future treatment. So it's this little nuance that comes into trials that I exploit in front of a jury. So one of the key things I raised during voir dire with a jury panel is I give them an example. You have two rockets going to the moon. One is possibly going to get there. One is more probably than not going to get there. Now, the jury may not be satisfied with either rocket, but I asked them, well, which rocket will you get on? 99.99 times out of 100, they say, I'd always get on the one that's more probably than not going to get to the moon. So you condition the jury to start thinking in terms of these little nuances. Plaintiff's doctors are going to say it's possible something happened, whereas defense doctors say, well, it's more probable than not. The other aspect that I focus on with jury trials involving TBI claims, actually all claims, is getting the jury to recognize the value of the scientific method. Now, kind of in our modern society, almost all of us know what the scientific method is, but during closing arguments, I will often argue to the jury that, well, the scientific method is what separates us from animals. Before, with the bubonic plague, which hampered people for hundreds of years, people thought that the bubonic plague, or the Black Death, was caused by bad air or demons jumping inside of a person's body. There was nothing objective to arrive at that conclusion, but that's what they thought. And now we have the coronavirus, where within a year after the onset of the virus, we did have a vaccine that significantly helped people with protecting them from developing COVID-19 later on. So, and that was the basis of the scientific method. The scientific method is what resulted in, which gave us electricity, what gave us the internet. The scientific method is what put man on the moon. And I also tell the jury that, well, the scientific method is someday going to free us from these masks we all have to wear because of COVID. And so I get the jury to really empathize and recognize that decisions need to be based upon things that are scientific, but more importantly, objective, not subjective. So second in jury instruction is proximate cause. In Washington, courts define proximate cause as a direct sequence that produces the injury complained of, without which such injury would not have happened. There may be more than one proximate cause. Damages that are claimed by a plaintiff need to be proximately caused by a defendant's conduct. A jury cannot base proximate cause on speculation or conjecture. And usually, not always, but usually medical testimony is required to prove that the plaintiff's injuries were proximately caused by an event. So if you have a plaintiff who says, I sustained a traumatic brain injury, they don't have a doctor that's going to say that, that's not going anywhere. One, saying that you have a traumatic brain injury is a medical conclusion, but two, damages, a medical condition as well as whether that condition is proximately caused by an accident has to be attested to by a medical expert. I've seen plaintiffs try to use vocational experts to say, yeah, this life care plan is proximately caused by the accident. Well, the vocational expert's not a medical doctor, and so they're arguing some medicine here. So, and also, the law states that medical testimony needs to be based on a more probable than not basis. And that's kind of the key here, because plaintiffs, I said, so often want to base their testimony on things that are possible. The last thing I wanted to kind of raise here was just the measure of damages. The court does instruct us to the measure of damages, but damages have to be approximately caused by an event, and that the burden of proving damages rests upon the plaintiff. Damages also cannot be based upon speculation, guess, or conjecture. The third central jury instruction that I kind of focus in on is this aspect of discounting things to present value. That's where the economist kind of comes into play. So I hire a bill review person to shrink the value of the bill down, and then I hire an economist to shrink the value of a life care plan and future wages down to present value. What is present value? Present value is the concept that $1 today is worth more than $1 a year from now. So if you need $1 in 1 year, you don't need $1 today. You don't need to give that person $1 today. You can give them, just say 82 cents, and they can take that 82 cents, invest it in the marketplace, and then a year later they will have $1. And so what happens with future specials and also future wage loss is that the economist is able to shrink the income stream and the bill stream down to present value. So you look at the plaintiff's life care plan, they say it's $10 million. The economist says, well, no, if you invested $500,000 today, this will be sufficient to fund that life care plan for the duration that's necessary. And then of course, that's assuming that you need a life care plan. I mean, defense experts typically say, well, there's no need for a life care plan. But the point being is that we want to shrink the claims of future damages, are all special damages, because the big benefit we get is if the jury makes that next step to general damages for pain and suffering. If it's a smaller amount of special damages, then it's going to be a smaller amount for general damages. That again is assuming that the jury is convinced the plaintiff needs future treatment. I mean, the science says most people recover from traumatic brain injuries. So the three key instructions I look at is I look at how the courts instruct the jury as to how to use experts and the basis for their opinions. Look at focus in on what experts' opinions are regarding proximate cause, and then if I have any expert that's going to discount damages to future to present value. The other aspect that I look at is possibly retaining a PI for video surveillance. When I take the deposition of the plaintiff's experts, specifically their neuropsych, I evaluate whether the neuropsych is recommending that the plaintiff needs a life care plan and what the values are for that future treatment. Because if that happens, the plaintiff's neuropsychologist all of a sudden stands to benefit from the jury's verdict. And that's a significant issue. Same thing with the VOC, but in terms of wage loss, so often plaintiff's VOCs will say that, well, the plaintiff's income capacity is a certain value, but if you look at their tax records, the plaintiff may never have earned that amount in their entire life. So the issue of capacity is kind of a red herring. So, in terms of valuing TBI claims, it's important to keep in mind juries do not assign a premium usually to TBI claims. It's like lightning. It happens, and when it does, it can be devastating. Usually, we see these these premium verdicts happening on borderline cases, such as you have a plaintiff who was the vice president of a company, about to be promoted to a CEO, but was involved in this accident and no longer can, work as a CEO. That's usually where you see these premium awards for TBI claims. The final aspect that I look at when evaluating TBI claims is just what is opposing counsel's skill set? Are they able to navigate all of the medical and legal issues that do happen and occur with TBI claims? Generally speaking, in terms of jury verdict searches, in Washington specifically, juries tend to look at whether there's any sort of permanency of the injury, after the accident, or whether they recovered. They look for notable declines in the plaintiff's previous mental and physical performance. But there are instances where a jury can award a high amount for general damages, even if the plaintiff has some retained intellectual capacity or has recovered to a certain extent on their memory or concentration deficits they had in the past. There were two jury cases I kind of want to bring to your attention. One was in Spokane. In 1996, jury awarded $3 million total. Defense counsel argued that the amount was excessive. Court said, no, the defendant is just typically ignoring, the severity of the plaintiff's injuries. But what was kind of significant here was that the defendant didn't really produce any evidence to fight against the TBI claims. They kind of walked into a lion's den and not prepared. There was also this 2015 King County case involving a TBI. Jury awarded $1.4 million. But the big issue there was not so much the damages. It was the jury was wondering, well, why is the plaintiff suing his wife? And the big issue here for the defense anyway was the court should not have allowed the trial judge to introduce evidence of insurance. And because at trial, the court read instructions to the jury about how the plaintiff had to sue his wife in order to trigger insurance. And that's something to kind of keep in mind when you're looking at TBI claims as well. As, are you inadvertently disclosing issues of insurance on this? The big takeaways with the jury verdict data is that there are no real major regional distinctions in Washington TBI claims from Eastern or to Western Washington. But the second big takeaway is that you need to focus on evidence of post-accident functional disability and also what is objective to support these claims of disability. When I'm evaluating a TBI claim, I oftentimes will look at, how graphic are the photos. I dig into the chart notes to see what the plaintiff is actually telling their doctors. I've actually seen instances where the plaintiff told their doctors, somebody told me I have a TBI, or, my lawyer thinks I have a TBI. And if you can attack the motivation for these claims of ongoing deficits, that helps you out as well. If the case is appropriate, and I know these mock trials are expensive, I think I've seen them up to $50,000 just for a one-day mock trial. But if the risks are pretty high, you might want to evaluate possibly using a mock trial. Big thing to keep in mind with these TBI claims is you don't want to bring a knife to a gunfight. You need experts. If you don't have an expert, you are kind of setting yourself and your insureds up for a premium TBI verdict. If you properly, if you've lined up the appropriate experts in order to refute these claims of TBI, that helps you minimize any sort of exposure with the TBI. So I want to go just real quickly on this. I know we're running out of time. I had two cases, Roybal versus Stone, Kelly versus Consuelo. Roybal versus Stone, my client, who was not able to express himself well, ended up running over a 7-year-old kid, sustained allegedly a TBI claim. And plaintiff had, I think it was a $5 million life care plan. Also alleging that his client's sustained a TBI. So, I hired the usual litany of experts that I needed, but I also utilized a computer animation expert because I thought it was important that the jury understand why my client didn't see the kid. My client was just ready to say, "Hey, I didn't see the kid," and the next question, is, well, why weren't you watching where you were going? You just ran over a 7-year-old little boy. So, we had the jury, we hired a computer animation expert who prepared a video of the pathway my client was taking from his vantage point inside the cab. We knew we were sunk in terms of liability, but we wanted to kind of give the jury an appreciation or, a understanding as to why my client may not have seen the kid. I mean, his head was slightly below the hood of my client's truck. It was dark out, there was rain, and so the computer animation shows all of these things. And we actually had a pretty good result on that. 3 days before trial, plaintiff settled with us, I think, for $500,000. They said they were going to ask for, I think, $6 or $7 million, and my client's policy limit was $1 million. So, yeah, we saved some money on that. Second was the Kelly versus Consuelo case. Case a little over a year ago, maybe it's 2 years ago now. The plaintiff alleged a whole galaxy of issues, including failed kidneys, created this life care plan, also argued traumatic brain injury, had $150,000 in past and future meds, and around $600,000 in past and future wage loss, and about a $4 or $5 million, as I recall, prayer for future damages. At trial, plaintiff asked for $21 million. And with this particular case, we had 3 separate accidents. So, and my accident was the middle accident. So what I focused in on was what is objective. What is objective in terms of whether the plaintiff sustained a traumatic brain injury or all these other issues as well? And what is objective in terms of what injuries were caused by my accident versus the other 2 accidents that occurred before and after my client's collision? 10 months before trial, we served the plaintiff with a $15,000 offer of judgment, and the jury returned a verdict of $13,400. So we beat our offer of judgment, but had we not retained the right experts and prepared that case for trial, it would have been significantly more than that. I think my client had a $50,000 policy limit, and yeah, it would have been much more serious had we not retained the appropriate experts on that case. So I think I'm going to go ahead and end this presentation here. I did just wanted to go through these other 2 cases, but we've run out of time. I wanted to see if anybody had any questions.
All right, thank you, Gordon. Yes, if anybody has any questions, go ahead and just put them in the little question box. We do have a few in here. So our first question is there a difference between a concussion and a mild TBI? Attorneys allege these all the time.
Yeah, I mean, this is why it's really important to make sure that not only we know what the plaintiff's experts are talking about, but also what plaintiff's counsel knows what the plaintiff's experts are talking about, because they use head injury, TBI, concussion as if they're interchangeable, and they're not. Typically, and this is just typically, a concussion is something that doesn't result in any sort of permanent or long-lasting neurological deficit. So with a concussion, you typically are not going to have ongoing like speech issues or hearing difficulties or balance issues or things like that. Concussion, in a layman's terms, is generally just kind of getting your bell rung. You typically don't lose consciousness with a concussion. I think you can. I think I've seen cases where the plaintiff did lose consciousness, but they were still diagnosed with a concussion. But generally speaking, a concussion is something that's temporary, that doesn't lend itself to long-term or even short-term neurological deficits. That's a great question.
Yeah, and then we have one more question. How would some other neurological problems such as MS differentiate with TBI?
MS, multiple sclerosis. All right. Uh, well, multiple sclerosis is a congenital issue. That is something that is not caused by trauma, at least as of today. I'm surprised how many times I've seen plaintiffs claim certain things that used to be congenital are now, they're saying related to trauma. But typically, I mean, multiple sclerosis is not something that's caused by trauma, whereas a traumatic brain injury, and that's where we're distinguishing brain injuries caused by trauma from brain injuries that were not caused by trauma. So traumatic brain injury, you have to have what's called that concussive event. You have to have something that caused trauma to the brain. That could be as little as just the whiplash example, where the head moves forward and then moves back and you bruise the brain, but you don't see any external bruising, to something that's more significant than that. But TBI claims you need to have some sort of an external traumatic event.
All right. We actually had some more questions come in as well. We'll go through those real fast. So this next one says, friends and family members often testify in these cases about the changes they've noticed in the plaintiff. These changes are real to them, although degradation may have been pre-existing. How do you minimize the impact of the testimony from friends and family?
Yeah, no, I mean, it's difficult to go up against sob stories. It really is. And but I always tie it back to things that are objective. So if I have a case that's going to trial and plaintiffs, experts, and friends and family are all saying that they've noticed a change in personality, I will bring out what the plaintiff may have said to doctors. So if the plaintiff told their doctors, my friend said I have a TBI, well, then that puts the question up, well, do you really have a TBI, or is it just because you think your friend says you have a TBI? More significantly is if you have like gaps in treatment. I mean, if you had a TBI, you would expect they would have some sort of treatment, and you wouldn't expect any sort of gaps. But if there's gaps, I exploit gaps in treatment. If there's evidence that the plaintiff had any sort of a normal life, such as post-accident, they went on vacations. I've had cases where the plaintiff actually continued to engage in athletic events, or we've had a case more recently where we did surveillance. One case, Roybal versus Stone, where my client ran over the 7-year-old little boy. Plaintiff, we had video surveillance of this kid who apparently had a head injury, but this video showed him riding his bicycle without his helmet while he's looking at his cell phone, and he's driving around this parking lot with one hand. We were able to get video surveillance of that. So that's how you go up against the testimony of friends and family, is you pull something that's external to what the plaintiff or the friends and family are saying. And that gets the jury to think in terms of, okay, why is the plaintiff's brother saying this, but we have this gap in treatment, or we have this doctor saying they don't have a TBI. So I always counter whatever the plaintiff, these sob stories are, with something that's objective, something that's beyond the subjective statements. And this really does illustrate the big fight with plaintiff's counsel. You have the fight with plaintiff's counsel, and they always couch things in terms of things that are subjective. Good defense is based upon things that are objective, or as objective as you can get.
Okay. Do you feel that a chiropractor can diagnose a concussion, or must it come from an ER?
Well, chiropractor does have some sort of training. I'd like to say no, I don't think they can, but I'm not a doctor either. What a judge will look at is, is this a condition that chiropractors typically conclude? Do they typically diagnose people with concussions? 30 years ago, when I first started practicing law, chiropractors could only talk about issues involving the spine. They couldn't talk about anything else, just the spine. Nowadays, they're able to talk about other things, even going outside about elbow issues, knee issues, head issues. So the question then is, well, will it survive a Daubert challenge? Is this a test? Is this the type of opinion that a chiropractor would attest to? I suspect you will lose the argument that a chiropractor cannot diagnose that condition. I think that it'll come in, but you look at, well, what's that chiropractor's training? What is their background? I mean, their background is in adjusting the spine, not on providing any diagnosis or treatment for the concussion. So that's kind of really the big battle there, is just minimizing the opinion.
Great. And then our last question of the day. Oftentimes, an MRI of the brain is done when there is a TBI claim. Are MRIs of the brain a worthy diagnostic testing device for TBIs?
Well, maybe to a certain extent, not necessarily. Mild traumatic brain injuries, you might have a normal brain MRI. So you look at these MRIs as kind of a piece of the puzzle. Now, an MRI is more objective than a patient saying, I have pain. But so if you have a brain MRI that's normal, from the defense standpoint, that gives us ammunition to say, no, they don't have a TBI. No, there's nothing. But the research has indicated that you can have a TBI without any sort of deficits or abnormalities in a brain MRI, for a mild TBI, that is. I mean, what doctors look at is what's objective, what's subjective. They will look at a brain MRI. They will also look at cognitive testing if they go down that route, or interviews with the patient. If the patient has slurred speech or their attention kind of drifts off, and they have to bring them back into the conversation, or if the patient says, I have a hard time trying to. This is kind of a common symptom where patients will say, I have a hard time filtering out things. So as I sit here in this exam room, I'm hearing that you doctor talk, and then I hear the fan blowing, and then I hear the cell phone down the hallway, and then the intercom, and you're hearing all of these things, and I'm having a hard time just focusing on what you're saying, doctor. That is also one of the things doctors look at. So brain MRIs are one piece of the puzzle, but it's not the only piece.
Great. All right. Well, I don't see any further questions. And just a quick reminder to everyone, if you do have another question that comes up, please feel free to reach out to us. Actually, Gordon can put his contact information on the slides here for you really fast, so that way you can access that if need be. Thank you all for coming in today and listening to our webinar. Like I said, I will be sending out that follow-up email with a survey and a place to enter in your license number here shortly. So just keep an eye out for that. And yes, just get in contact with us if anything else is needed, but otherwise have a great rest of your day.
Thank you.